Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. We come to you today to discuss the January 14th Supreme Court opinion, Case versus Montana. In this case, the Supreme Court unanimously affirmed that police officers may enter a home without a warrant when they possess an objectively reasonable basis to believe an occupant needs emergency aid. The court rejected a proposed probable cause requirement for such entries, maintaining that the standard for rendering aid differs from criminal investigations. In this instance, Montana officers acted reasonably by entering the petitioner's home after he threatened suicide and a witness heard a gunshot. The decision clarifies that the Fourth Amendment allows warrantless entry to prevent serious injury or death without requiring the higher threshold used for investigative activity. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to written rundowns. Just search the High Court Report. And if you have questions about this case, kassen zo mij schrijven, rij en zo etrijoj out via LinkedIn or email scotus.cases.pod@gmail.com. Let me walk you through Case versus Montana, a unanimous Supreme Court decision that clarified when police can enter your home without a warrant during emergencies. Picture this. William Case calls his ex-girlfriend and tells her he plans to kill himself. During that chilling phone conversation, she hears what sounds like a gun cocking, followed by a pop sound, then complete silence. When she calls his name repeatedly with no response, she dials 911 and races to his house. 3 police officers respond for what they call a welfare check. These officers already knew Case's troubled history, alcohol problems, mental health struggles, previous suicide threats at work, and one prior incident where he seemed to try provoking police into shooting him, what experts call suicide by cop. The officers knock on doors and shout through an open window. No response. They shine flashlights inside and spot empty beer cans, an empty gun holster, and a notepad with writing they believe contains the suicide note Case mentioned on the phone. Here comes the crucial part. The officers call their supervisor and spend 40 minutes deliberating outside the house. Finally, they decide to enter to render emergency aid. When one officer steps into a bedroom, Case suddenly throws open a closet curtain while holding what appears to be a gun. Fearing for his life, the officer shoots and wounds Case in the abdomen. Case survives, and officers find a handgun near where he stood. The state charges Case with assaulting a police officer. Case fights back by filing a motion to suppress all evidence from the home entry, arguing the warrantless entry violated the Fourth Amendment. Think of this as Case saying, "You can't use anything you found in my house against me because you had no right to be there in the first place." The trial court denies his motion, ruling the officers legitimately responded to an emergency. A Montana jury finds Case guilty. Case appeals to the Montana Supreme Court, where things get legally messy. The Montana court upholds the entry under what they call their community caretaker doctrine. They rule that police can enter when objective, specific, and articulable facts would lead an experienced officer to suspect someone inside needs help or faces peril. The court rejects Case's argument that officers must have probable cause to believe an occupant needs emergency aid. This creates a problem. Different courts across the country apply different standards for these emergency entries. Some require probable cause, others use a lower standard. The U.S. Supreme Court steps in to resolve this confusion. During oral arguments, the battle lines became crystal clear. Case's lawyer argued that the court should require probable cause, meaning police need facts showing a fair probability that an emergency exists before entering any home without a warrant. Montana countered that the existing objectively reasonable basis standard from a 2006 case called Brigham City provides sufficient protection while allowing officers to save lives. What stood out during arguments was Justice Kagan's pointed question about whether importing probable cause from criminal investigations makes sense in emergency situations. She noted that probable cause developed through decades of criminal cases, asking whether that framework even applies when police try to help rather than investigate. Justice Gorsuch dove deep into historical common law, exploring whether officers have the same authority as private citizens to enter property during emergencies. Meanwhile, Justice Sotomayor pressed hard on the specific facts, noting that multiple officers on scene believed Case wanted to provoke a confrontation rather than actually harm himself. Justice Kagan delivered the court's unanimous opinion, joined by all 9 justices. The court affirmed the Montana Supreme Court's judgment, but criticized their legal reasoning. The core holding, police may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant faces serious injury or imminent threat of such injury. This restates the standard from Brigham City versus Stewart, without requiring probable cause. The majority reasoning focuses on context. The court explains that probable cause develops specifically for criminal investigations and fits awkwardly in emergency aid situations. When police investigate crimes, they ask whether evidence shows someone probably committed an offense. When police respond to medical emergencies, they ask whether someone probably needs immediate help. The court notes that emergency aid operates in a non-criminal, non-investigatory setting where the probable cause framework would create confusion rather than clarity, rather than force criminal investigation concepts into emergency response. Brigham City simply asks whether an officer had reasonable grounds for believing entry was needed to prevent serious harm. The court criticizes Montana for using language from reasonable suspicion doctrine that applies to brief street stops. When officers stop someone on the street, they need specific and articulable facts, creating reasonable suspicion of criminal activity. Montana borrowed this language for home entries, but the court clarifies that Brigham City established a different standard specifically for household emergencies. The court finds the officers had objectively reasonable grounds for their entry. The information from Case's ex-girlfriend, combined with their on-scene observations, suggested Case might have already shot himself or would do so without intervention. Key factors included Case's known mental health history, the alarming phone call describing suicide plans, sounds of gun preparation followed by silence, Case's failure to respond to police calls, and visible evidence like the empty holster and apparent suicide note. The court dismisses Case's suicide by cop argument, noting that while officers considered this risk, the circumstances justifying entry were those suggesting Case had already harmed himself or would do so immediately. Justice Sotomayor wrote separately to emphasize unique considerations for mental health crises. She points out that police presence sometimes escalates rather than calms situations, potentially endangering both occupants and officers. She cites statistics showing individuals with mental illness face disproportionate risks during police encounters. Sotomayor suggests officers should consider alternative de-escalation methods before entering, such as speaking with occupants from a distance, contacting family members or friends for help, calling specialized crisis intervention teams, or working with mental health professionals. Despite these concerns, she agrees this entry was justified because facts suggested Case had already harmed himself, not that he was merely waiting to provoke police. Justice Gorsuch grounds the decision in common law tradition rather than judicial policy making. He traces historical development of necessity defenses in property law, showing courts have long permitted entry onto another's property to prevent serious physical harm. Gorsuch argues that Fourth Amendment interpretation should follow common law lessons rather than mere intuition. The common law emergency aid rule generally allows entry when necessary or reasonably appears necessary to prevent serious harm, subject to requirements that the entry be reasonable in manner. He emphasizes that officers enjoy the same legal privileges as private citizens under common law, providing a firmer foundation than judicial instincts about privacy expectations. This decision clarifies emergency aid entry standards nationwide, rejecting attempts to impose higher probable cause requirements. The unanimous ruling provides clear guidance for law enforcement while maintaining Fourth Amendment protections through objective reasonableness testing. The decision affects how police, firefighters, and paramedics respond to wellness checks, domestic violence calls, medical emergencies, and suicide prevention scenarios. Rather than requiring officers to calculate whether they have sufficient evidence to convince a judge, the standard asks whether a reasonable officer would believe immediate intervention was necessary to prevent serious harm. The concurring opinions add important nuance. Sotomayor's emphasis on mental health considerations and alternative approaches, plus Gorsuch's historical grounding in common law principles. Together, they provide a framework that balances individual privacy rights against society's interest in preventing serious harm during genuine emergencies. This case resolves years of confusion among lower courts about emergency entry standards while maintaining unanimity on the court, a rare achievement in Fourth Amendment cases that often divide the justices along ideological lines. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email scotus.cases.pod@gmail.com.